Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss a judgment authored by Chief Justice of India, Justice Dhananjay Chandrachud, Justice P.S. Narasimha and Justice Pardiwala, where they make it clear that no immunity from statute merely because the contract is entered into in the President of India's name. To get more details on this and get you a brief explainer, we have Tahira Karanjawala, who joins us today from Karanjawala and Company. She'll explain you the basic facts of the case before we move on to the observations by esteemed panelists. Senior Advocate Saurabh Kirpal, a leading advocate at the Supreme Court of India and the Delhi High Court, joins us from the city of Delhi. I have with me Ma'am Neha Nagpal, his founding partner of NM Law Chambers. I have with me Advocate Abhimanyu Bhandari, who practices at the Supreme Court of India and Delhi High Court. I have also Manmeet Singh, partner with Saraf and Partners, who in a sense, it drives the litigation practice or the dispute resolution practice as Saraf and Partners. He joins me today. Good to see all of you. And may I request Tahira that in about 2 minutes, if you could, in a sense, for the viewer to understand what are we getting at today, if you could explain, and then we move on to the comments. Over to you, Tahira.
Thank you, Tarun. So, Tarun, basically, what this judgment deals with is whether a contract which has been entered into in the name of the President, which is a contract basically on behalf of the Union of India, which is entered into in the name of the President, whether the general law of arbitration applies to such a contract. So briefly speaking, in this case, what had happened is that the Union of India had entered into a contract for the supply of about 30,000 Glock pistols with a particular company. The arbitration clause in that particular contract contemplated that the Secretary of the Ministry of Home Affairs will nominate a serving officer of the Law Ministry to adjudicate and arbitrate any disputes which arise under that contract. After the contract was completed, disputes in fact did arise, and the question was whether this arbitration clause is violative of Section 12(5) of the Arbitration Act, or whether because it has been entered into under Article 299 of the Constitution in the name of the President, whether it stands on a different footing. So just to give you a brief background, post-2015 amendments in the 1996 Arbitration Act, 12(5) was inserted, which prescribed basically that if the arbitrator in question has a particular relationship with parties to a dispute or the subject matter of the dispute, which is under one of the categories set forth in Schedule 7 of the Act, then such an arbitrator will be ineligible to arbitrate the dispute. Examples of the bad categories were if an employee is chosen as an arbitrator, if the arbitrator is a person who has represented one of the parties in a different dispute, if you have some family relationship with one of the parties to the dispute, or if you've been directly concerned with the subject matter of the dispute, and so on and so forth. There's a large list of categories. This law was introduced in 2015 pursuant to certain Law Commission recommendations. Also, the Supreme Court of India, in two pertinent judgments, has expanded this law to mean, in the judgments of TRF and Perkins, both landmark judgments, that any arbitration clause which contemplates that the manager of a company will either arbitrate, of the government company will either arbitrate a dispute himself or will nominate any other arbitrator to arbitrate the dispute, will also fall foul of Section 12(5). So this was broadly the law which has come into existence post-2015 in the realm of arbitration. So the argument sought to be canvassed by the learned ASGs in this particular case was that because this particular contract, being a contract which has been entered into by the government of India in its executive capacity under Article 299 in the name of the President, that it somehow stands on a different footing from normal contracts, and therefore it should somehow be exempt from this particular application of law 12(5). So this is broadly
Thanks. Thank you for explaining and explaining to the viewers what this is all about. I'll go to Senior Advocate Saurabh Kirpal for his comment on this judgment by the three esteemed judges. But let me also state at the outset that legally speaking, we are also unabashedly, in a sense, pro-business, because this country's demographic dividend will be realized if enough businesses pour money into India. There is business confidence in India. And I'm happy to note that the Supreme Court of India in the recent few years have, in a sense, ensured confidence in businessmen, be it the law of bails, where they have made their, in a sense, vocal comments time and again. Even now, from that perspective, Saurabh Kirpal, may I request to come in, because in India, where there is a lot of litigation in every business that happens, we look up to the court sometimes to be standing with the businesses, because an investor sitting in London and New York looks for this. Over to you, Mr. Kirpal.
Yeah, you're absolutely right. As a prelude to the discussion on Article 299 and immunity, which are all very abstruse concepts, but the fundamental thing that the court has done is to ensure that the faith of a common person in contractual sanctity is maintained. They basically said that the court will hold both the citizen and the state at the same level when it comes to entering into a contract and being held to be bound by it. Because there is a need for that. You see, ultimately, and that is the history of Article 299, which is in part 12 of the Constitution. There's a series of articles. And the Constitution recognized always that, of course, private people will do business, but even the state can do business. So the state also enters into contracts for that purpose with various persons, either for the function of the state, for instance, procurement of things in hospitals, which is part of its sovereign functions, but it also enters into other contracts, which are, for instance, when the court runs a hotel like Ashoka, etc., they're ITDC, they enter into contracts because the state does business. Now, the problem arose, and it was anticipated by the constitution makers, and in fact, it goes back to the 1935 Government of India Act, that if the state is to enter into a contract, how do you ensure that the contract that the state enters into is something that some authorized officer has entered into? Because state doesn't act through some amorphous entity. It has to act through a person. So when you sign a contract, it has to be a person. So the Article 299 of the Constitution basically says that when a state, the Union of India or various states enter into a contract, they will enter into a contract which is in writing. It will be entered into by a person who's authorized to do so. And that authorization must be in accordance with rules. Now, this is to protect the state from certain of its people, certain errant officials entering into contracts on behalf of the state, to which the state is bound, but doesn't know anything about, because some person is just acting on its own behalf. So this was a protection. This was given to the state to protect itself from these errant officials. But this argument that was raised in this case, saying that, look, because we have protection against errant officials in Article 299, now absolve us from all statutory liabilities and impositions that are cast upon other people. Now, that I think is I wouldn't say a cheeky argument, but a very ambitious argument. Because effectively what they're saying is that the rest of the people are going to be bound by the rigor of Section 12 of the Arbitration Act, which is an act to ensure neutrality of the arbitrators. But when it comes to the Government of India, then they're immune from that. And why just the Arbitration Act? Because if this argument is taken forward and they're immune from Section 12 of the Arbitration Act, then effectively the state is saying that we can do whatever we want to. And in any contract that we have signed, we are not bound by it because it is in the name of the president. Therefore, the normal rules that apply to contracts don't apply to us. So the Contract Act will not apply to you. All the other acts which regulate the contractual activities of the state will not apply to you. And that will be chaos. That will be fiscal chaos. So it is good that the court has now stepped in and said, no, that the same principles that apply to a private citizen apply to you. And Article 299 has no place in a contract like this, which has been signed and duly authorized by the person. That's the
point very well taken also, because enforcement of contracts against the state has become difficult these days. And I think I have enough and more cases to count here. That doesn't instill confidence. Of course, the courts of law are playing a stellar role here. Secondly, what I also noted in the past few years is, do we give the reverse benefit to a private party? If he says I had, in a sense, managers who were not trustworthy and they entered into a contract with a malicious contract with the state, we couldn't deliver what we were supposed to. We don't give them that benefit. Why should state get the benefit after having signed into a contract? I'll go to Advocate Bhandari for his intervention.
Thanks, Tarun. Tarun, on 299, I think this is a judgment which is now very well clarified and confirmed what the law has been since 1966, when Supreme Court in the decision of KP Chaudhary versus the state of Madhya Pradesh said that all that 299 is concerned with, that it sets out what are the conditions which have to be satisfied when a government or a state is entering into a contract with anybody. And those three conditions, as Saurabh said, was one, that it has to be expressed in writing. It has to be signed in, if it is by the state, then by the governor or on behalf of the president. And the person who's executing it has to be authorized in accordance with the rules and by a competent authority, so that he is actually authorized to enter into this contract. And largely, this was done to ensure that errant officials don't sign away contracts on behalf of the state and bind the state if they are not authorized. So I think that, this argument that 299 gives the state some kind of an immunity was anyways an argument which was a bit far-fetched from the very beginning. But good and welcome that the court has confirmed the position since 1966 that, 299 cannot provide immunity to anybody. And I think that instills a lot of faith, because if such an article can be used for a government to say that I am not bound by the terms of the contract, it would create complete anarchy and chaos in our civilized society. But Tarun, what is great about this judgment is, of course, the 299, the reiteration of the law under 299. But more importantly, what is very exciting about this judgment is that it goes on to expand and confirm the judicial dictum in Perkins. Do understand, Tarun, that after Perkins, when the decision of the railway officers case came up, where the court said that no, although Perkins says that one person can unilaterally not appoint an arbitrator because he may have a vested interest in it, then came the decision which has now been referred to the larger bench, which this judgment refers to, which was a railway officer's decision, where because it was not a sole arbitrator, but it was a tribunal, and therefore the Supreme Court said Perkins will not apply, and the government can unilaterally appoint about 3 out of the 4 people in a tribunal of their own choice, without taking the consent of the other party. And there Perkins was in a way diluted, and that of course is now today being examined by a constitutional bench. And therefore there was a little bit of an uneasy as to, is there going to be a shift in the trend where we are going to see subsequent judgments which will dilute the rigors of Perkins? But no, Tarun, this judgment comes as a huge welcome and boost to India's commitment to arbitration. And this judgment clarifies, although in a completely different context, that look, under 12.5, an employee of the state has a conflict of interest and therefore cannot act as an arbitrator. So therefore, and what is also more important is that 12.5, as Tahira rightly said, came into existence in 2015. This person who was selling Glock pistols to the government entered into a contract in 2011. And I think this is the first judgment which says that a 2015 amendment and the rigors of that amendment would apply even to an arbitration agreement entered into between the parties in 2011, much before the Arbitration Act was amended. So I think this is, I don't know, I may be wrong, but it's a welcome judgment, because the 12.5 amendment, which came in 2015, has been applied to a 2011 contract which parties had entered into, because 12.5 begins by saying that notwithstanding anything. And therefore, I think this judgment is highly welcome, because it reinforces that arbitrations have to be done in an impartial manner. Now, Tarun, just one last comment, and this is more on a policy platform. India, in all these international arbitration conferences that we go for, we keep hearing people moaning and groaning that, oh, you have this whole law on arbitration which says an arbitral award cannot be appealed, and therefore the grounds of appeal are not there. But, you can challenge it on certain very, very few grounds of patent illegality, etc. But courts are clogged with cases after cases where arbitration agreements are being challenged. On the other hand, you hear arguments, people making that, look, this arbitration law has become too strict. There is really no an appeal against an arbitrator's award, and you're left with very minuscule grounds on which you can challenge the decision of an arbitral award. Therefore, to restore that balance, it is important that we have a system of impartial arbitration. Largely what is happening, Tarun, is that not only in India, but around the world, there is now a growing slight judicial trend, or there is a more kind of, people are now have started also saying that arbitration should not become a crony way of resolving disputes. And let me tell you, in very civilized nations where commercial courts move very quickly, court systems are not clogged up, there many people are preferring the court system because they feel that there may be certain trappings of an partiality in an arbitration system. I'm not trying to make any comment here, but I'm just generally trying to say that there are arguments to and fro for arbitration all around the world. And therefore, this judgment reinforces that, look, if you're going to have an arbitration, it has to be an arbitrator who is going to be completely impartial and should also be seen as being impartial. And therefore, a servant of the government of India, an employee of the government of India, cannot be an arbitrator. So I think this sends out a really positive message, and it reinforces what Perkins said.
Thanks for that intervention. Really positive message also at this point in time in our country, where we need the investments to be going up so that our, in a sense, greenfield manufacturing grows. The government wants it. All of us want it. We need this. I'll go to Advocate Neha Nagpal. You see various states of India, state governments, I mean. The central government also enters routinely into PPA and other contracts. There is a huge fear that if, private parties get discriminated against in the might of the state, it will hit the business sentiment. And keeping this in mind, how would you view this judgment by Justice Chandrachud, Justice Narasimha and Justice Pardivara?
I think I agree with Abhimanyu to the extent that he says that this is a very defining judgment. It sort of really does, make things very clear. It balances interests and also protects the business community. Because the state, when it contracts with in capacity of a vendor or a supplier or a purchaser, is actually not just the state, and it's a twin hat that it's wearing. And I think then they cannot first want to get into the commercial realm and then step back when there's trouble. I think there has to be that consistency of this is a commercial transaction, and they have to honor it in that manner. I think the spirit of this judgment honors that. It does not give them the immunity. It also draws them to a parallel with any other contracting party to say that nobody connected with you can then be appointed as an arbitrator, because there is a direct conflict of interest. Yes. And it was with that mindset that Section 12(5) was introduced by way of the 2015 amendment. And there is a very detailed, the 246th Law Commission report on that, which also factored in this, that the fact that when there are the government is a contracting party, it is imperative that there has to be more caution that has to be played, that there is no ex-employee or employee of the government that is in any manner on the panel. So I do think it's a very welcome step to once again reiterate that, to reiterate the confidence of the business community in the judiciary.
Okay, point well taken, Manmeet. At your law firm, Saraf & Partners, you do this advising on the corporate side to a lot of parties in writing of contracts that they enter into with the government. Keeping that in mind, that you know how tough it is, because if you are very good at entering into contracts with the government, Indian infrastructure companies would have been the biggest by market cap in the world. These are not my words. These are words of Mohit Sarafi in a show mentioned to me that, Tarun, there's this huge misconception that, Indian infrastructure make lots of money. If that were the case, we would have some of the biggest in the world, like we have in other sectors. In your experience, if you could share with me, A, what are the problems that happen and how this judgment is good and gives hope?
So, Tarun, as you said, we are a capital-starved country and we need a lot of foreign debt and equity to come in. And therefore, for the government to argue, like Saurabh said, that it is not really an argument which also works, to my mind, in their favor, to say that the contracts where they are a party somehow constitute a separate class and 12 Section 5 should not apply, for the reason that if that were to happen, then you would actually increase the cost of doing business in India. foreign investors, foreign suppliers, everybody would want to price in that risk that somehow contracts with the government are a separate class and therefore would be treated and enforced differently. Now, it is also directly contrary to what the government has been trying to do, which is to have India promoted as an arbitration center. So if the government for its own contracts were to take an argument that, look, we are a different class and 12.5 would not apply to us, it's a where does this argument stop, right? Now, thankfully the Supreme Court has interpreted the law as it has. Any other interpretation would have been a slippery slope. I don't know what next the government would have argued as to what other provision of Indian law does not apply to it. So I think the judgment does reaffirm rule of law, which is very important for bringing down costs of doing business in India, promoting India as an investment destination. And as you said, the biggest brunt of this is felt in infrastructure sector, where every contractor for instance, any change of scope claim that you may have, you are forced to go into arbitration because the authority does not do what it should be doing. Like, for instance, if you just go back to the facts of this case, the performance bank guarantee was kept alive for 10 years. It is only after 10 years that Glock refused to renew it. The contract required it to be kept alive for 40,000 rounds and 18 months in supply. Now, presumably 40,000 rounds didn't happen over a period of 10 years, but the vendor kept it alive for 10 years. If after 10 years, he has not kept it alive, A, you've taken the bank guarantee. B, you say that the ordinary provisions of Arbitration Act should not apply to you because it's a separate class. So India does have its challenges, and I'm quite thankful that Supreme Court has interpreted the law in the manner that it has.
Thanks for that intervention. See, now we only have about 5-6 minutes to go. Since this judgment came from Justice Chandrachud, Justice Narasimha and Pardiwala, one is the current Chief Justice of India, two are going to be the Chief Justice of India. The past few months since Justice Chandrachud has taken over have seen a great pro-business push where, the businesses are, in a sense, feel confident because it's about bails, now it's about contracts. And we remember even government ministers saying that a lot depends on the court if Make in India has to be a success, if investment has to be a success. So I think we should end this show by, a short comment each on the stellar role played by the Supreme Court. And what do you feel about it? But very short comments. We'll start with Tahira, move to Saurabh and so and so forth. Tahira, your final comment about the role played by the courts under Chief Justice of India, Justice Dhananjay Chandrachud.
Thank you, Tan. So I think, as you correctly said, that the Supreme Court has rightly stepped in and, reaffirmed the faith of the business community as far as, engaging in business with the government is concerned. And while, frankly, I think this law was clear even prior to this judgment. And as Manmeet correctly said, I feel like this was the only logical decision that could have been given by the Supreme Court. But it is very nice to have it clarified, both as far as 12.5 is concerned and 299 is concerned. Because frankly, 299 to argue that, 299 was in... It was only it only prescribes a formality of a contract. In no way does it contemplate that the substantive laws of this country do not apply to any contract which is entered into with the government. And frankly, this was clear back in the Constituent Assembly debates. This exact question was raised. And it has been clarified back in 1949. So for this argument, to sort of, have been given any credence at this stage, would not have been expected. But I'm glad that the Supreme Court has, of course, come in and stepped in and clarified that position.
Point well taken. Senior Advocate Saurabh Kirpal, your comment on role played by the courts in the recent months.
Yeah, ultimately, the courts have done what the court's duty is, which is to ensure that there is a rule of law. The belief ultimately that businesses have a problem within India is the sheer unpredictability of the legal regime. Today, you enter into a contract thinking that this is the law, this is the way it will apply to. Tomorrow, you could find that the law has been changed, or if you get an award in your favor, they will undo the basis of that, or that they will say the act does not apply to me. So all these escape routes now start coming into action. Whenever things go against the government, that is when government starts changing the rules in the middle of the game. And that is completely antithetical to the rule of law. That is a constitutional value, really, at the end of the day. It is not just about ease of doing business. ease of doing business is simply a business which is as entitled as a person under our constitution to have the same rights as anybody else, which is the right of predictability and the ability to just go about its work in a normal way. We are not doing something exceptional or currying favor to a big business by saying you have a right to predictability. This is a normal way. I think every day, any citizen who lives their life expects a certain degree of predictability, right? So it is the courts now coming to the rescue of the businesses and ultimately holding the government to account, saying that you cannot do all this. You cannot start changing rules and saying that whenever Section 12 applies to you, sorry, I'm exempt. Any rigor of the law, I'm exempt. And ultimately, you have heads I win, tails you lose. That is not how business can be done in our country by anybody. Individuals, large businesses, small, medium enterprises, anybody who has interacted with the government knows that how difficult it is to deal with the babu there. So it is time that the court stepped in and reminded government that I am sorry, you are also bound by Article 299, etc., but you're also bound by the statutes of this country, the laws of the country. Be you ever so high, the law is above you.
Point very well taken. I'll go to Advocate Abhimanyu Bhandari for his intervention.
So I think, Tarun, we've seen some great decisions in this area of law recently. The Honorable the Chief Justice Court holds the Section 11 roster. So if there's an international arbitration and an arbitrator has to be appointed and parties are not agreeing to, then it goes to the Supreme Court directly for appointment. And there have been a couple of decisions which have come recently, and they all are quite pro-arbitration. For example, just before this decision, there was another decision where the court reaffirmed that, look, Section 11 court is not merely to just, as a postmaster, appoint someone as an arbitrator, but cases which are completely dead wood, for example, patently barred by limitation, or, there's a settlement agreement, and therefore there's no need to put people into arbitrations, then we at Section 11 stage can interfere and, ensure that parties don't have to go through a cumbersome arbitration process. After that came this decision, and this decision is very good in many respects, because as I said, Tarun, everybody was a little worried after the Central Organization of Railway Electrification judgment came, where really Perkins was watered down and was distinguished as not being applicable to the facts of that case, because it was not a sole arbitrator case, it was a tribunal of multiple arbitrator case. I think that this decision reaffirming and citing Perkins positively is a real big boost to the entire sentiment of arbitration, because I think if we go down our history of arbitration, we kind of unanimously ask any lawyers, what are the 5 or the 10 top judgments in arbitration? I think Perkins will be in the top 5 for sure, because I think Perkins has sort of rightly said that it's not just about ease of doing business, and therefore Perkins was not just about making it easy for people to do arbitration, but was to repose faith in our judicial system, that when you get a decree, whether you get it from a civil court or from an arbitration, you should be confident that it has been adjudicated upon in the most impartial manner. And Perkins reinforced that very basic concept of rule of law, that justice is blind, and someone who has an interest in a consequence in an arbitration or in a dispute should not be able to decide who the judge is going to be. So I think that whole good environment that Perkins set has been reaffirmed by this judgment.
Point very well taken. I'll go across to Advocate Neha Nagpal, founding partner, NM Logic.
I would agree that this is definitely sort of reiterated the position that, there is consistency in the approach of the Supreme Court when it comes to commercial arbitrations. There is also consistency in the larger scheme of things of promoting India as a destination for arbitrations, and definitely that this is a safe and easy place to do business. I think all three of them, these three themes come out largely from this judgment once again.
Point well taken, Manmeet. From Saraf and Partners, whenever we go abroad, lawyers go abroad, they get asked how easy it is to do business in India. Is there predictability? Can I get my money out once I put it in this country? Your final comment.
So we always say that at some stage, the courts will read the law right. And I'm glad that the Supreme Court has interpreted the fashion that it has. So in fact, they've done the union a favor. In my view, by ruling against the union, they've done the union a favor.
Point very well taken. See, to end this show, I must say that the past few months have seen a very pro-business approach. Even on the criminal side, when you give bails to businessmen who ought to be running businesses and not to be spending time behind, unless convicted, of course, that was a big push. There are several other judgments which we can cite where the Supreme Court has taken an approach which gives a message to the courts down below. And now this judgment. That's why we continue to take such issues up. The government wants it. The people of India want it. The youth of India want it. That businesses feel free to invest. They feel free that they are whatever margins of 10, 15, 25%, they'll be allowed to take with respect, and they'll be treated with respect because they generate jobs for India. That's it for now. But I would like to thank Senior Advocate Saurabh Kirpal, Taira Karanjawala from Karanjawala and Company, Advocate Abhimanyu Bhandari, Neha Nagpal, founding partner of NM Law Chambers, Manmeet Singh, partner, dispute resolution practice with Saraf and Partners. Appreciate your joining us on this very, very important issue. Looking forward to have you all on the next one. Thank you so very much.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.